Um, last week, was it kind of 2 weeks running? This is the third week that we're seeing good activity. And my gut, this is not politically charged or economically charged or anything like that, but my gut says we all have to like attack the fall market, immediately. Hopefully you've already attacked it. July and August were slow, which tends to happen, but I think this July and August were a little slower than normal. And I think the new world, the new trend is that when there's a reason to take a break, people take breaks, which is nice. To have like a little balance in life. I remember back in the day, everybody would just, power through holidays and nobody, cared to, let up a little bit. But now I think our business is nice because you work hard for a few weeks or a few months and then there's a break. There's lots of breaks, So, work hard when the time comes and then relax when there's a reason for it. But, whether it's a bottleneck kind of idea where people are on the sidelines. I've spoken to sellers who want to sell, even if they sell at a loss. There's buyers that want to, hit the ground running this fall market. So I think there's just, business from life events naturally happening and naturally occurring, and people are interested. I mean, I know there's a little bit of a misnomer. A lot of listings that are new to the market aren't really new, right? They're from 6 months ago, and they're just kind of were taken off the market. Now they're back on the market. So there's different layers there. But our activity is solid. We have deals of all price points from 300 to 10 million and above. I actually had two $10 million deals die yesterday that were just about to be signed. Actually, one was new, then they went to see a third look at the place, didn't like it. The other one, the buyer, just personal reasons, again, nothing. I think he just doesn't like the carrying cost, and it's not their primary residence, backed out. But on the flip side, we had two other big deals signed this week. So number one, I think, just a little motivation. You need to like don't ease into the fall market. I mean, the fall market's here, right? So there's a lot of cool events happening. There's a lot of, meetings at your office. Like go all in, email your clients, text your clients, really I would get motivated there. Also, I was talking to my firm about this at our firm meeting. We consider kind of the fall market the new year of real estate, right? It's, people are fresh, right? We just had time off from the summer. Like, hopefully you're recharged, hopefully you're energized and ready to go. And use that energy, to learn something. Pick one thing. And I guess to your credit, you're here now, right? So pick one thing in the next month that you want to learn, not three things, not five things, not 10 things, and learn it, right? Whether it's legal related, brokerage related, financing related. Um, that's my kind of words of wisdom. And for this kind of discussion, we'll send you a follow-up email with a presentation. And if you have questions, obviously you can contact us. So it's 11:05. We will get started. Thanks everybody for joining. I'm here with my colleague Chris Curtis. So I'm the real estate guy. Chris is the international guy. Chris will, give a little intro, but obviously the firm represents buyers and sellers of residential property. By the way, we also do financing and commercial work, the full gamut. So if a buyer or seller comes to me through you guys and they're an international buyer, I'll loop on Chris, right? I'll talk about the real estate. I'll educate them about the ins and outs of purchasing and selling. But then, of course, our extra value added, which is a nice to be transparent selling point for us, is the international element. I don't think any of our friendly competition really has this in house. They typically we'll refer it out and, once you get non-real estate lawyers involved in our deals, things kind of get delayed. So I always say when we do these presentations, um, if you can walk away with one thing, it's more about issue spotting. You don't need, to know everything or even 99% of what we speak about. I want to give you a frame of reference. Chris and I want to kind of educate you. But the analogy is clients ask me accounting questions, right? I'm not an accountant, but a client asks me a question. I'll float the conversation for 30 seconds, a minute, and then I'll say, hey, I'm not an accountant. I know what I know. I know what I don't know. Sometimes I use that cheesy line and let me refer you to an accountant, right? So don't, you're not expected to know everything, but as a broker, I mean, I would expect you to have resources, right? Inspectors, contractors, things of that nature. So very simple. If you get introduced to international buyer, right off the bat, and there's lots of competition, right, for you just as much as us. So maybe they're not working with you right away. Maybe they're kind of shopping around for a buyer's broker. Um, Initially, one way to add tremendous value and show that you're sophisticated and educated is say, hey, listen, I just went to a seminar, with an attorney that specializes in work with international clients. It's my understanding that if you purchase a property in your name individually, right, as opposed to an LLC or an entity, which Chris will get into, there can be huge estate tax ramifications, up to 40%. So if you buy a property in your individual name, you pass away, the IRS can tax you up to 40%. So there's also, if you've heard of FIRPTA, which is a withholding, when you buy and then eventually you're going to sell, the IRS will withhold 15% of the sales price until they determine what the capital gains is. So who wants 15% of a million, 2 million, $5 million withheld for a year? And it could take a year in today's world. So the idea is this can all be avoided legally by purchasing in a structure or entity as opposed to buying individually. If you learn nothing more than that, you're way ahead of the game. So again, as an international buyer, typically you don't want to buy in your individual name. We should speak to an attorney to discuss different options. And it's not one size fits all, unfortunately. It depends on the country, depends on their assets, depends on their presence in the United States. So that's why it's a more of a discussion. And when you refer me, it's 15 minutes, 20 minutes. I go through the process. The clients are ready to go. This is more like a consultation. I don't know if any of you have done estate planning. Chris does estate planning, of course, for domestic clients as well, people that live here. That's like a real consultation, right? You're talking for an hour, then they're thinking, they're filling out lots of forms because it's a very buying real estate's emotional, but when you're thinking about who you're giving your assets to and how your kids are going to be taken care of, I think it's like even a level higher on the emotional scale, right? And then I'll let Chris go and come jump in a second. If you have a seller that's international, unfortunately, if they own in their names already as opposed to an entity, it's too late probably to transfer it. But this is the stuff we want to get ahead of. Chris and I'll never forget about a year ago, 2 years ago, we had a client selling, it was a high level property. He was actually a sir, not just, he was, I don't know the correct terminology, but he's coined or he was, I don't know, he was anointed, sir, maybe I'll just say anointed. And he had an army of financial advisors. I mean, he literally had 5 people on the phone, and none of them even knew about this. So when he bought, we didn't represent him when he purchased. He wasn't advised. So he sold, I think, a $10 million property and sent $1.5 million to IRS. And he has a team that he's paying around the clock. So it's crazy that with so many professionals involved, that this isn't discussed more. And of course, clients will blame everybody. Everybody likes to point the finger. So it's just issue spotting, and it's a great way for you to add value. So that's my long little intro. I'll let Chris kind of give a little background on himself and dig into the kind of the nitty gritty. Again, we want to give you some ideas. Of course, for example, most international clients shouldn't buy co-ops, right? It's usually a condo or house or a new development because co-ops don't like the structures. And we'll talk about some practical implications towards the end, but I'll let Chris get technical. And if you have questions, go for it, because especially with this kind of topic, there like literally is no stupid question. It's more technical. So any question you have, your colleagues will have as well.
Yeah. So just as a way of introduction, as Andrew mentioned, I'm Chris Curtis. I co-head the Trust and Estates Department here at Chaves Perlowitz Luftig. But I also have a niche practice area with dealing with international clients. Prior to coming to Chaves Perlowitz, Luftig, it's 4.5 years, going on 5 years now. I was at a boutique firm for almost a decade, and that's what we specialized in. We were a trust and estates boutique firm. We specialize with a lot of international clients, and then that included establishing structures for our clients to invest in real estate here in the United States, usually New York, Florida, but mostly in New York. So I then came to Chase Pro It's Lifting, and me and Andrew got talking about international clients. And I would say that I was probably the nightmare. I was one of those lawyers that was a nightmare for brokers because they, like Andrew said, if you don't have it in-house and you send it to another firm, tend to take things slower, don't realize the urgency of real estate transactions, and there were a couple of times the clients lost the deal because due to the analysis time, right? So one of the benefits of being here at Chaves Pro It's Lifting is that Andrew quickly taught me the um, the importance of urgency. And so what we try to do now is like we try to work hand in hand, right, to keep the deals moving. Because the questions that and the issues that we look at here, especially of international clients, they could be relatively simple, they can be relatively complex. We always want to look at it calmly. But at the same time, we don't want a deal to get lost. So we work together um, to figure it out, right? To put the client in the best type of structure um, for their objectives, particular objectives, and while keeping the deal moving, so that when we go to closing, the client purchases in a structure that they are comfortable with, and that works for them, right? And then in the end of the day, everyone wins because then the client feels safe. They feel that they've got their real estate here. They're happy, and they're also feeling pretty good about the tax implications as well. And let's just talk about the tax implications here, because Andrew just touched on them very briefly. Um, but yeah, what are the tax implications for U.S. For non-resident aliens, right? For people, for international clients? Well, like you said, the biggest one is estate tax, right? Estate and gift tax, but I'll talk more about estate tax. You're usually one today. And what is estate tax? Estate tax is the death tax. It's a death tax that's charged if you die. Okay, so if you die, your estate has certain property, and it's worth more than a certain amount of money. There is the potential for both a federal estate tax and also a New York State estate tax, at least when we're talking about real estate located in New York City. Now, that estate tax can be up to, like Andrew mentioned, up to 40% of the fair market value at the date of death, right? Now, mentioning this, some of you are probably wondering, like, oh my God, this is such a big deal. Why aren't I having to plan for it, right? Why haven't I heard of this if it's so large? Well, because the reason being is because if you're a U.S. citizen or you're a non-citizen but considered domiciled in the United States at the date of death or a gift is made, each person in that case has an exemption of $15 million per person, right? So you pay zero estate tax for any gifts or assets you leave at death up to $15 million. So it doesn't affect 99.9% of the population. That's why you don't hear about it so much, especially with your domestic clients, right? My domestic clients, especially when we're dealing with estate sales of domestic clients, there's rarely any sort of estate tax owed because of the exemptions are just so high. It's $15 million on the federal level exemption, and on the New York State level, it's a little under $7 million. It's adjusted for inflation every year. However, it's very different for international clients, those that are not US citizens and those that are not living in the United States. Your classical clients that want a pied a terre here, or maybe they want to buy an apartment for their son or daughter because it's going to go study NYU, or maybe they're looking for a rental property, an investment property, or so forth. For them, it's very different. If they die with real estate in their own individual name or an entity, what I call a transparent entity that they could be taxed on, their exemption is not $15 million. Their exemption is only $60,000, right? And anything above $60,000 is subject to estate tax of up to 40%. Um, Unfortunately, not a lot of buyers know that. And it's not surprising, really, because buyers that come to the market, especially here in New York City, it's a happy occasion, right? To look for real estate, to buy it, and so forth. It's exciting. And so they tend to go into it. They don't really think about tax consequences. They're not talking to an accountant or a specialist in this area. Not all accountants, not all tax attorneys are even specialists in this area with non-resident aliens. And they tend to talk to real estate attorneys. No offense, Andrew, but real estate attorneys know their stuff very well. They know real estate, but they don't know tax consequences naturally, right? So then what ends up happening is they buy the real estate. I've seen this happen before, usually in their own name and or in an entity that's really not going to help them that much. And then they get the unpleasant news after purchasing. Maybe it's right after, maybe it's years after purchasing. I've had this conversation on all sorts of occasions where I say, hey, do you realize that if you die, there's going to be a huge estate tax that's going to be owed? And then they get shocked about it. Like, oh my God, why didn't anyone mention this to me? Why am I only hearing about this now? And to make things worse, after closing, after the deed has been recorded, what ends up happening is certain rules called FIRPTA come into play, right? That's where you have a transferor or a seller that's a foreign person. Some of you might be familiar with it. There's a 15% withholding on a sale by a foreign person that Andrew just touched on. But that's only a part of the law. The FIRPTA laws are very strict. They recognize they require recognition of gain. What that basically means is it gets very, very difficult post closing to put it into a structure that would avoid the estate tax, right? Not impossible, but more difficult, right? So we always try to catch these before closing, right? And to put them in a structure so we won't have this issue in the future, right? Now, what kind of structures are there out there? Well, it really depends on the client. Like Andrew said, there's no type of perfect structuring out there. I create offshore companies for my clients to purchase in. Sometimes I create an offshore company that then owns a New York corporation that that the client then owns. The reason being is because shares of an offshore company are not subject to U.S. estate tax, right? Sometimes, depending on the value, if it's not too high, it might just make more sense for the client to purchase in their own individual name, but perhaps buy a life insurance policy, for instance, right? We also have to factor in the income tax considerations, obviously, because when we tend to decrease the risk of U.S. estate tax, we tend to increase the income tax bill, right? There's like no perfect structure, really. Everything has a pro and con to it. So we always try to be as forthright as possible with the clients, try to present them a very accurate, complete picture, and then let them make the decision, right? So at the end of the day, it all depends. Are they going to get rental income? Are they just going to use it for a part-time? Maybe they even want to make a gift to their child, right? Which might be more beneficial. Child's younger, less risk of death, and so forth. So these are the things that I try to keep in mind when we're dealing with international clients, right? Now, like Andrew mentioned, we're probably throwing a lot of information your way. And these things about exemptions and everything like that, no one expects you to know them. Like a lot of attorneys don't even know it, right? Or accountants. The key here is just issue spotting. If you see someone, especially someone that's from abroad and buying like a pied-à-terre, or even someone that's maybe even on a temporary visa, right? They could be here on like an H-1B visa, right? Temporarily, and they're looking to purchase property. It might make sense for them to have a conversation about it while they're in the process. I'm sorry, Sarah?
Is it the same with a green card? Or is a green card treated like a US citizen?
Yeah, it depends. It depends. So, and that's a good question, actually, because when I mentioned that people who get that higher exemption, that $15 million exemption, are non-citizens considered domiciled in the United States. Now, the term domicile, we have a term of non-resident alien and resident alien for income tax purposes, right? So if for income tax purposes, the rule is sorry, go ahead. Sorry. The rule for income tax purposes is what I call very objective, right? It's very clear. You For income tax purposes, whether you're considered a U.S. income tax resident, have to file like a resident and pay tax and report on all your worldwide income, there's three categories. There's U.S. citizen, there's green card holder, right? They're always U.S. persons, U.S. taxpayers. And then the sort of the catch-all third is whether you pass substantial presence test. Basically, you spend more than 183 days of physical presence in the United States, regardless of what your immigration status is, right? If you do that, you're a U.S. person for income tax purposes, right? The rule is different for, and this is where a lot of people that kind of look into this and go onto like Google Law School to look into it kind of trip up, because the rule is different for estate and gift tax. Estate and gift tax is a subjective criteria. Domicile for that is different from income, right? So you could be considered an income tax resident for U.S. income tax purposes, but a non-domiciliary for estate and gift tax purposes, still subject to only that $60,000 exemption, right? And let me just give you a very quick example, because you bring up the green card. You have people with green cards. I'm dealing with one right now. They hold on to their green card and they never come and live in the U.S. Or they lived in the U.S., then they leave the U.S., but they never give up their green card, right? So they're still U.S. income taxpayers, right? As long as they keep holding the green card. But for estate tax purposes, they're not living in the U.S. anymore. So they're non-domiciliary. So that's the worst of both worlds. You're subject to income tax, U.S. income tax, but you don't get the benefit. So these are the kind of things I talk through with clients and I discuss with them. Having said that, that's pretty rare, but we also have to factor in, for instance, are they going to come to the United States, right? I don't want to put them in an offshore British Virgin Islands company if 2 years from now, if they're in the middle of an application for an EB-5 visa, right? And they're going to be living here, right? And the intent of it is for them, because then I'm going to have to undo that structure like 2 years from now, right? If they decide to become a green card holder. Do they have kids that are U.S. citizens? We have to factor that in too, because what happens if the kids inherit the property? We want to put it in a structure that's more manageable for the kids, right? So there's a lot of different factors there going on. So what our job here is to do at the end of the day, and I work with Andrew, I go through it. While Andrew's dealing with the real estate side of things and the contract and all the nuts and bolts of the closing, I'm looking at more of the substance and, okay, let's figure this out. What's the best approach for you, right? For the client. Now, at the end of the day, and I've seen this happen many times, I'll explain everything to the client, and then the client might just say, you know what, this is only going to happen if I die. Not my problem. It's like, they can inherit and pay whatever tax they want. And I get that sometimes, which is fine. It's not a problem. It's their money. It's up to them, right? But the key there is they've made an informed decision, right? So they can't, if that happens, no one can come back to them and, they point the finger at me or Andrew or you, the realtor, right? They've made that informed decision. So at the end of the day, it's just at least having that conversation, right? I would say, probably out of all the conversations I have, I would say about, I don't know, maybe like 30 to 40% don't end up doing any structure. They just don't think it's worthwhile for whatever reason, or they just want to accept the risk. Maybe they'll sell it before they die. No issue there, right? So, but everything, at the end of the day, you want the client to be making that informed decision, right? You don't want them to, you don't want to be making any assumptions on their behalf, right? So that's basically in a nutshell, in terms of estate and gift taxes, right? Now, in terms of FIRPTA, let's just touch on FIRPTA here. We got this thing called FIRPTA withholding. You guys might, pardon me if you've already known this or dealt with it, but for the benefit of those that might not know what is FIRPTA withholding? FIRPTA withholding is basically, FIRPTA stands for Foreign Investment in Real Property Tax Act. It's from like 1980. It's been around for like a good 45 years now. Basically, what does FIRPTA do? Well, FIRPTA, primarily where you're going to see it, is when there is a foreign seller, right? There's a foreign seller of real estate in the United States. It could be co-op, could be real estate, could be whatever. It could be a company that owns real estate, so the shares are considered real estate. So it touches on a lot of different types of structures. The basic idea for FIRPTA is that at closing, the buyer must withhold 15% of the entire purchase price independent of the gain or loss recognized by the foreign seller. The foreign seller could be making a loss. Maybe they purchased for 1.1 million, they're selling for 1 million, right? It doesn't matter. The buyer is obligated under federal law to make that 15% withholding and send it to the IRS, right?
Just
Why
a
does
quick
that?
note, just a
Yes.
quick note, just to give draw an analogy. The same thing really applies to non-New York residents. So the IRS has a withholding. New York has a withholding too. The New York's a little easier because you can pay an estimate at the closing. You don't have to withhold it. But basically, the idea is if you're selling a property and you live in Florida, California, and you haven't lived in New York a total of 3 out of the last 5 years, you send in an estimated tax. The idea, think about this, like if you're out of New York or you're out of the country, New York State and the IRS doesn't want to have to worry about chasing after you for the money. What happens if really, your full-time property is in Mexico and you're selling a property here and you only have one property here, you don't really have connections to the US. You sell that property, the IRS doesn't hold back money, you can get away with not paying it, right? They're not going to come chasing after you. So just to give you some context, and there's a fair reason for it. It makes a lot of sense. It's not like a penalty. It's basically the IRS in New York State making sure they get paid taxes that are due and they don't have to chase after people.
Yeah. And it's important to mention there that because a lot of clients have a misconception that it is a tax. It's not a tax. It's a withholding mechanism to ensure that any tax is paid. So the best way to look at it is the IRS is holding that 15% hostage, right? So they take that 15%, which bites for most people, it hurts, and they say, okay, under the law, you're meant to file a non-resident income tax return to declare, and you have to declare what tax you owe. You have to calculate the basis, just like any US taxpayer has to do, and then pay any tax on any net capital gain. And we will credit that from that 15% holding any tax that you owe, and any amount that was over withheld, we will refund that to you, right? So you have a client, $1 million, the 15%, it's a foreign seller. 15% is $150,000, right? Right off the bat, that's going to be on the closing statement, $150,000. That's sent to the IRS, right? And then in theory, what happens is with a foreign seller is they file, let's say they've made a loss, so they tell, oh, you know what, I made a loss, so give me all my money back. Eventually, the IRS is going to issue a refund of that $150,000 check. Astrid just wrote here, and this actually is a good segue into my next point. There's a question here. The federal is backed up too, so that FIRPTA could take years, right? At least 1 year. Yes. It depends on the timing of the withholding, right? Or sorry, the timing of the sale, right? So let's say for instance the sale happens in January, right? It happens in January and the withholding is made in January. The issue there is that the foreign seller can't file a tax return for that tax year until the following year. So they have to wait a whole year just to file the tax return to request the refund. And then after they file the tax return, then it could take several more months to get the refund, right? So if they close in January, then it could be like they could be looking at like 1.5 years before they get that refund. Oh, and by the way, they don't get interest on that. They do not get interest until the following year, until April 15th of the following year. So they're making a loan, an interest-free loan to the IRS, to the US government, by the way. So that also hurts as well. Compare that, for instance, to a closing happening in December. Let's say a closing happens December 31st, right? Great, because then they can file within a couple of weeks, right? When the IRS starts accepting returns. So it can vary wildly in terms of timing, right? Now, I do want to touch upon there are mechanisms to request a reduction in the withholding or an elimination of the withholding. Pre-pandemic, I used to do a lot of these for my foreign seller clients. They're called certificates of withholding. Basically, you put in an application to the IRS, Form 8288B. You give the IRS a full calculation of the net capital gain with all the documentation and so forth. The IRS pre-pandemic would take around 90 days to review it and then send a letter saying, okay, we're allowing a lesser withholding, right? Sometimes even down to zero. Even pre-pandemic, we would get these letters after closing, and the buyer's obligated to send the withholding in within 20 days of closing. After otherwise, there's like pretty severe penalties. But the rule was that if you waited, if you already had an application submitted to the IRS, you could wait past those 20 days. We would do like a post-closing escrow, FIRPTA escrow. That was pretty common. And then once I got the letter, the seller's attorney would release the funds to the foreign seller with a copy of the IRS letter. That worked. That was a good system. That actually worked really well. Unfortunately, the pandemic just absolutely caused chaos. Like it shut down for a year. They were just piling up the applications. They had to throw millions of them away. Like they just didn't even they didn't even analyze millions and millions of applications just because it was just such a ridiculous backlog. And they've never really climbed out of that hole, to be honest with you. The FIRPTA office is in Ogden, Utah, and it seemed like things were improving up until last year. But then the new administration came in and basically fired like half the IRS, including, by the way, there was a big uproar I saw in the news of the Ogden Center that does FIRPTA. Like they laid off like a lot of people from there. So I don't expect that to get better anytime soon. And not only that, but due to the huge backlogs, law firms that accepted to do a FIRPTA post-closing withholding, like escrow withholding, they got burned really bad with that. Because what ended up happening, instead of waiting just a few months, they would wait like over a year without a response from the IRS. And then it would cause all this chaos and confusion because they're like, well, if, because the money's in the account, it's not the IRS. So there's no letter from the IRS, so the foreign taxpayer can't make an application because the IRS can't refund what they don't have. It was pretty unprecedented. And you've had all these, real estate attorneys that are like, this is crazy. I completed this closing a year ago and I'm still holding on to this money. And my God, my liability. So that completely kind of put a freeze on FIRPTA post-closing escrows. And to be honest with you, I don't see a point where it's going to come back anytime soon, that system, unfortunately, right? So what I tell the clients is don't rely on that. Actually, that sir that we talked about, that particular client, unfortunately got some bad advice. I wouldn't say bad, I'd just say incorrect or out-of-date advice. They were waiting on the IRS to get back to them. And they were, his advisor was convinced that the IRS was going to give him back anytime soon. I was like, this is nuts. It's not happening. And so we had to do it another way eventually. And it was very frustrating for everyone involved, the realtor, us, and so forth. The client was very upset. So these are the but one thing that our structuring does is not only to avoid U.S. estate tax or gift tax, but there are structures that we can create to avoid the FIRPTA withholding. And, sometimes clients don't even care about the estate tax, but hey, they're going to sell it in the future. They don't want that 15% withholding. We can create a structure to avoid that, right? But that has to be done ahead of time. We always have to think about when we're purchasing, we have to think about the sale in the future, right? Because if you're thinking about it at the time of the sale, it's just not going to work because it's just going to be very transparent for everyone, including the sellers, the buyer's attorney, that you're just trying to avoid the FIRPTA withholding, right? And that's too much liability on a potential buyer. So that's about it in a nutshell. So, basically in sum, what we try to do is we try to avoid, mitigate the U.S. estate and gift tax, and we also try to avoid the FIRPTA withholding in the future, right? We put them into that kind of structure, and then it works out for everyone, right? And then no one gets any unpleasant surprises, especially the foreign seller in the future with the FIRPTA withholding. And just to give you guys sort of an idea, like a real world example, I'm dealing right now with two estates, two foreign estates, And it was a husband and wife who owned a co-op in New York City. And they owned it for many, many, many years. Okay. And they were very elderly. And unfortunately, the co-op share certificate was in their own individual names. When by the time they died, they were non-resident aliens, not domiciled here. And I was approached after both of them had passed away. And one of them had passed away, in like November, and then the second spouse passed away shortly thereafter, right? A few months afterwards, right? Not a big surprise. They were very elderly. What the issue was, though, when the heirs and the Spanish attorneys reached out to me to help with the whole probate procedure here in the United States, I had to break the news to them that there was going to be I think it was around a $220,000 estate tax on a co-op that was probably valued at around $600,000, right? And the IRS wants that money within 9 months of death. So, uh, and you can't sell estate tax liens. So we're working through that right now. But these are the kind of issues that we're trying to avoid, right? If they had engaged in the proper planning, or I had a conversation with them prior to their deaths, we could have avoided that $200,000+ estate tax bill. So, and we would have avoided even a probate procedure. We would have likely been able to sell it, and the heirs would have gotten everything without all the carrying costs involved, right? So there are real world consequences to this, and it's always worth trying to get ahead of it. So I see the chat right now, and I'm just going to look through it. So Anne, so Anne's question is, so what can we do to protect the buyer here when they buy from a foreign person? So it's a good question. So the responsibility to protect the buyer is obviously the buyer's attorney, right? The buyer's attorney should be on top of this. Fortunately, Andrew, I think we've come across a lot of situations where they don't know the FIRPTA rules very well.
Yeah, well, there's in the contract, the seller has to state if they're a foreigner.
Yeah.
So, and at closing, the seller has to sign an affidavit that they're not a foreigner. So it would be a misrepresentation. We're going to figure it out in the contract and the closing. That's how we're protected. It's not our duty as a buyer's attorney to investigate it and figure out. It's their duty to disclose it.
Right. Yeah. And just to add to that, if there are obvious indicia of the person being foreign, right? They don't have a social security number, or and they even tell us. They tell us, oh, I don't live in the United States. I'm a non-U.S. taxpayer. I'm not a U.S. citizen, not a green card holder, and so forth. Very rare for that to happen, by the way. But you can't stick your head in the sand, right? So and accept the affidavit that they typically give, but that's usually not how it works, right? And at the end of the day, it depends who's selling, right? If it's a domestic corporation like a New York corporation, then it doesn't matter who the shareholder is. There's no FIRPTA. If it's an LLC with more than one member, even if both members are foreign, like a husband and wife, no FIRPTA withholding, because that's taxed as domestic. A domestic partnership. LLC with one foreign owner is subject to FIRPTA, by the way. A lot of people get tripped up on that. So the rules can vary. They're very, very technical, right? But yeah, generally speaking, as Andrew mentioned, it's the sellers that have to make the disclosures, right? That's on them. Unless there's something very obvious they're saying, or the seller has already mentioned to the buyer that the buyer just can't simply ignore. Sorry, I'm starting to get a lot more here. Hang on, let me try to get through these. Jalon is, I don't think there is any risk to the buyer here when they buy from a foreign person. It's the seller who's not getting paid in full. Yeah, and Jalon, it's like Jalon, that's a good point to make. Whenever in doubt, right, we say withhold, because the buyer's obligation is fulfilled when that 15% is sent to the IRS within 20 days. When that is done, the buyer's liability ends. Okay, so whenever in doubt, we say withhold. Um, Grace, how much do you realistically need to set up a structure? It really varies on the complexity, on the value of the purchase, client's objectives, so forth. I would say it could range from I've seen anywhere from structures from $5,000 to $20,000, right? It really does vary, and it depends on the obviously the higher amounts are for much for assets worth millions and millions of dollars. I'm not going to put someone in a $20,000 structure for $500,000 a studio apartment, right? That they may sell in a couple of years, right?
And
So we really
actually,
have to balance the things out. Yeah, sorry, go ahead,
to that
Andrew.
point, yeah, we should have said Chris is really good at with our domestic clients that want anonymity. So we've done I guess it's more of the high level stuff, but sometimes not, where they just don't want their, whoever, the public knowing that they purchased. So the structures can apply to regular domestic clients, but just so you know, if you're buying a primary residence, usually you want to buy in your name because if you buy an LLC, you lose a real estate tax deduction. So it depends again if they're, primary residence, if it's an investment property for sure, if it's a second home. A lot of situations, clients have to balance the cost benefit if it's a primary residence, if they want to, purchase in an LLC, a trust, they can still get the tax benefit. So there are layers. Most clients, if it's a primary residence, like they'll buy in their names, but again, it's definitely an option for them not to buy in their names.
And I would, and raise a really good point on privacy that we should also mention, not just for domestic clients, but international clients. Because an important point here that I see of a lot of international clients is there's a lot of countries out there where real estate records aren't as open as the United States. Real estate records is sometimes in some countries are even treated like tax returns, right? Like why is it anyone's business to know who's on the title as long as the government knows, right? So that's not the case here, obviously. You can go on Acris. We're very open with our deeds, even more open than a lot of other common law countries. Um, and a lot of foreign buyers don't realize that, right? And I've had this happen a couple of times where a foreign buyer or a foreign owner of real estate they probably bought several years ago comes to me and says, "Hey, I bought the real estate. I didn't realize that, anyone could Google it and see that I owned it, this multi-million-dollar apartment. And there could be reasons for it. They don't want family members to know about it, or they don't want, they live in a dangerous country where there's kidnapping issues. And then they're like, and then they tell me, they're like, well, can you help me? Can I hire you to get my name off? And I was like, well, I'm sorry, I can't do that. And neither can any other attorney out there because that's on the chain of title now. And it's going to be on there till the end of time. So, and they get very upset about that. So even if tax is not an issue, like a estate tax, England, they just don't care. At the very least, it might be a privacy thing. They might just say, you know what, I just don't want my name on the deed. So that's for foreign buyers. That's when it makes sense for an LLC because it won't necessarily avoid LLC in of itself wouldn't avoid an estate tax issue if they die, but it will avoid keeping their name off the deed and off the chain of title, right? And keep things private. So I have seen that. But we also combine it. You combine tax planning with privacy planning as well. But this is, like Andrew mentioned, this is something we do a lot with our domestic clients, right? The high net worth clients that don't want their names to appear. We do it a lot. Sometimes we use LLCs, sometimes we use trusts or a combination of them. Like Andrew mentioned, typically we try to avoid LLCs. It's going to be a primary residence for our domestic clients, just because there is a tax abatement in New York State property tax abatement for a primary domicile on the and it can save from anywhere from 17 to 28% on property tax, which is huge. But LLCs don't qualify for that, period. So what we tend to do to maintain privacy is typically I form like a trust and I act like as a first trustee and so forth. I sign all the documents so their names don't appear. And then And in that way, we maintain the eligibility for that while also maintaining their privacy as well. Anyway, let me just get some of these questions here because I think we're running out of time. But Justin, is the LLC structure used most? Corps can be very difficult to insure for property insurance purposes. For personal residences, LLC much easier there than common entities use. Justin, yes, I do use LLCs, but for primary residence, we try to avoid LLCs. Just not only for what you mentioned, it does make things more difficult, but also for financing and so forth. But they also can't qualify for the property tax abatement in New York City for condos and co-ops. And not only that, but if there's more than one owner, a husband and wife of an LLC, then they can't use the IRC 121, the up to $500,000 on the capital gains tax exemption for the sale of a primary residence in the future. LLCs with more than one member don't qualify for that. So I try to steer primary residents away from LLCs. Some don't care. Some just like they're very, very wealthy and they're like, I don't care. I just want my privacy. So then, yeah, we throw them into an LLC, perhaps with a trust and so forth. LLC, Justin, I'll say is the most common one. It's just the most flexible entity. And sometimes you're right, Justin, that I've seen lenders that just do not like corporations. They prefer LLCs. And so what we tend to do is to maintain the sort of the tax benefit, I'll throw them into an LLC, but then I'll do what's called an 8832 election to treat the LLC as a C corp, just like a corporation. So then you kind of get the best of both worlds, right? Everything entirely depends on the client and the objectives again.
Just a quick commercial break. Justin is a insurance agent, so premises and liability. So if your tenants, your renters, I'm sorry, or your purchasers, you should always refer them to get insurance, right? Premises and liability insurance in case someone slips and falls, there's a flood, there's a leak, fire. Justin, if you want to put your contact information in the chat, Justin is a great resource. Everybody should have an insurance professional refer to our clients.
Yeah. So next question is Preeti. I have a young lady who is Canadian and is here on a work visa and wants to buy. Should she buy a condo in an LLC too? Again, depends on the client, but my initial instinct here, Preeti, is not to buy in an LLC just for the reasons I mentioned. If it's going to be her primary residence, you want her to be able to maintain all the benefits of that primary residence, such as the discount on the property taxes on a primary residence in New York City. This is actually a good question because she's Canadian, and I just want to throw out there are certain countries that have estate tax treaties with the United States. Canada is one of them, so it kind of for Canadians, for instance, and for UK citizens also have a tax treaty. The planning might be different because the exemption can be higher depending on the circumstances, right? For that one, I would probably say no. She might be young. I'd probably say I'll look into her objectives. I'll see, look, are you going to stay here permanently? Are you going to back to Canada? Are you going to get a green card? What's the deal here? Because if she stays here permanently, she gets that $50 million exemption, right? If she doesn't, I'll probably, and depending on her age and health, I would say life insurance policy, right? Life insurance policy, just in case, right? And then that way, you keep things very, very simple. I like to keep things simple with the clients. I don't like them putting them in structures that I don't think is advantageous for them or is worthwhile. All right. Justin writes, when representing a foreign buyer purchasing a 2 million plus in New York who doesn't yet have a US credit score or social security number, what strategy do you recommend to make sure the closing isn't delayed? So I think that kind of more goes, Justin, I think that goes more to the point of their sort of, whether it really depends what they have, right? So obviously co-ops are a whole different animal because they delve deep into it. And I don't like co-ops for international clients. Number one, just because international clients aren't used to that sort of, they think it's very invasive. They're really, really not used to it. Most people aren't, even in the United States, the questions co-ops ask, number one. And number two, co-ops just are not, they don't like structures that I typically put together for international clients, right? So condos, on the other hand, They want to see finances. It tends to be a lot more limited, although these days some condos love to think they're co-ops. Um, Again, it also depends. Are they getting financing? Usually, if they're getting financing, what I typically see is they usually have an account here, a private banking account, and so they usually do some sort of collateralized loan, which also avoids the mortgage recording tax. And that gives some comfort to the U.S. lender, so they're not relying on income or assets located outside of the United States. But we have ways to get around that. Um, Grace wrote, I have an international buyer like that, no social security number, and what implication they face. They do it with an LLC. So, an LLC, for instance, let's say they buy it, for instance, directly in the name of an LLC and they're the sole owner. An LLC really, they'll give them privacy, but not much else. It's not going to protect against estate tax. Or it potentially protects against gift tax. They want to gift the membership interest of the LLC, but that's about it. If they die, there's still going to be an estate tax because an LLC is considered disregarded entity, so it's taxed to the individual taxpayer. Social security number is not an issue, by the way. 99% of international buyers do not have a social security number or an ITIN. You don't need that. You don't need that at all. It's a common misconception that you need it. Um, so obviously, if they buy in an entity, then they can get an EIN for that entity, a taxpayer ID number for the entity. But ITINs and social security numbers, not only do they not need it, but you have to qualify for it. For a social security number, you have to have either work authorization or be a U.S. citizen. For an ITIN, you have to have a reason, which is usually the filing of an income tax return, which the vast majority of international buyers don't have a reason to do that, and neither do they want to. Lisa writes, I have a buyer client living working in New York City with a new green card, an American spouse, and kids. The couple wants to purchase in both names. Upon death of either spouse, would the estate be treated as that as a foreigner? So good question. No, it wouldn't be treated as a foreign estate. Green card holder, like I mentioned, is always going to be considered a U.S. income taxpayer, assuming the buyer client lives permanently and is resident here in the United States at the date of death. He would be considered as domiciled in the United States, so qualify for that $15 million exemption at the time of death. And that the estate would be treated as a domestic estate. Like if you die domiciled in New York, the probate goes through the New York Surrogates Court, for instance, and so it'd be a domestic. Now let's just assume they buy it as husband and wife, which is most usual case, right? And that's probably what I'll recommend here, Lisa, by the way, tenancy by the entirety. Just keep it simple. Husband and wife, if they decide to do it jointly, there's a right of survivorship if one of them dies. Highly unlikely to be estate tax in that situation, depending on his or her net assets or their plans for the future. All right. Certainly, if he dies and the spouse survives him, there's going to be zero estate tax because there's something called the unlimited spousal exemption for a surviving spouse. But that only applies to surviving spouse, a U.S. citizen. And I don't want to get too much in the weeds here. Jaylon, trusts is what I've seen the most for primary residence. You still qualify for that. That's absolutely correct. If it's a trust, especially like a revocable trust or even an irrevocable trust where they are a beneficiary of the trust, then they qualify for the New York City condo co-op abatement. That's why we use them for privacy for primary residences. Jaylon, again, so foreign person buys an LLC, they die, they still owe, yeah, Jaylon. So if they buy an LLC and they die, they still owe the 40% because they're considered as holding. The asset that they hold is what matters. They hold assets. If a non-resident alien, not domiciled, dies, then estate tax depends on whether they hold a U.S. situs asset. Okay, it's very technical. Suffice to say, if they hold U.S. real estate or co-op shares directly named, that's a U.S. situs asset. If they hold a interest in either directly in a U.S. corporation, U.S. LLC, that's a U.S. situs asset as well. So they would still be subject to it. So LLC helps for privacy, but not for estate planning, for estate tax purposes. We'd have to do something in addition to that to protect it. And Grace, one more question here. For a $4 million cash purchase by a foreign buyer for a third recipe, I'd say which ownership chart structure? It depends. I'd happy to have a conversation with them, but third residence, pied a terre. There's different ways we can approach it. I could do like a domestic foreign partnership structure, irrevocable trust if they're willing to release control over it, perhaps gifting to family members, perhaps creating an LLC where we have different family members as LLC members, so forth and so forth. So I'd need more information for that. But I'll definitely consider something because $4 million obviously big chunk of money, and 40% of that would be a lot. If you die, Sarah writes, if you die as an American domiciled in New York, but all of your relatives receive the money are stationed outside of the USA, not citizens, the $50 million exemption apply? No, not confusing at all, by the way. Yes, it does apply because they're not looking at who's inheriting it. They're looking at who died. Okay, so it's like that's why it's called an estate tax. It's charged to the estate of the person that died. So yeah, they still get the $15 million, and then there's no U.S. inheritance or estate tax owed to the beneficiaries who are foreign. Now, whether or not those foreign beneficiaries, have to pay something in their home countries, that's another thing, but certainly not in the United States. All right. So
I'm just gonna.
thanks
Lots
for
of
all the questions, by the
This
way.
is
It's
this is
very,
amazing.
very engaging today.
Yeah,
Most
I do
engaging
have a phone
audience
call
I've
at
ever had.
noon, and I'm gonna hop off in a second.
And yeah, and I do have to
And
hop off as
I know
well.
Chris has to go too, but we'll send you an email with our information if you have follow-up questions. I'm gonna jump, but and Chris, I don't know if you want to answer one more, but certainly email us. You have all our information. But these are the best questions we've had yet. We've done this a lot.
Yeah, absolutely. Yeah, absolutely. Had a really good time with this. You guys have been great. And look, any additional questions you may think of after this, feel free to reach out. Shoot me an email. Okay, happy to answer them. We're happy to be a resource to you guys as real estate professionals. All right. Sarah, hang on a second. I think they put it, but let me just put my just writing my email here right now. And you can always find me on Chase Perlowitz Luftig's website as well, obviously. So all my contact information
Yeah, I
is
think
there.
our information's up top as well.
Okay.
Thank you both so much.
All right.
I just
Thank
added
you.
the
All right, guys.
contact information to the chat if anybody wants to copy it.
All right. Thank you very much, everyone. Thank you for joining us, and take care. Happy Thursday. All right.